Welcome to our first panel, Gregg in Context. I'm so thrilled to have with us today three of the wisest and most influential voices about the founding period of the modern American death penalty. Michael Meltzner and Evan Mandry, who are here on the panel, have written what I and I think most people regard as the two most insightful books about the events that culminated in first Furman versus Georgia and then the 1976 decisions. Evan's book covers the Gregg versus Georgia opinions as well, and those books are really essential to understanding the events that transpired both politically and legally to produce first temporary abolition and then restoration of the death penalty. George Kendall, who is also on this panel, has been a long-time influential litigator in capital cases and an important strategist for those who are concerned with limiting the reach of the American death penalty. So I'm thrilled to have all three of them. And the first speaker today will be Michael Meltzner.
Can you hear me? It's working? In the brief time I have, I'm going to touch on some themes that are going to be very familiar to you. And then leading to a comment on the nature of the work that many of us do. I call my remarks "The World According to Gregg, Ironies, Muddles, and Mental Health." Much the way Michelangelo saw the outlines of a finished sculpture in a crude block of Carrara marble, the problem of capital sentencing standards, the question of who should live and who should die, was imagined long before 1974 when Troy Gregg was convicted of murdering two men who picked him up hitchhiking. But rather than going back to Benjamin Rush and the Pennsylvania experiments of the 1780s and 1790s, I begin with Herbert Wechsler. When I moved from the NAACP Legal Defense Fund to the Columbia Law Faculty in 1970, Herb was probably the most prominent law teacher in America. He'd been a Supreme Court clerk, a Nuremberg prosecutor, co-author of two books that changed the way criminal law and federal practice were understood and taught, and of course the force behind New York Times v. Sullivan. Most significantly for my purposes, he was the reporter and prime mover of the ALI, the American Law Institute's model penal code that had been years in the making and was finally approved in 1962. He graciously agreed to an interview for the book I was writing about the LDF campaign that led to Furman. We met in his office. It was a space that was impregnated by the smoke of about 10,000 cigarettes. His voice was gravelly. He had a habit of not looking at you directly and delivering answers to questions with mini lectures. This was a guy who spoke in paragraphs. But he could also be brusque, and you might think the phrase, "he does not suffer fools gladly," was invented with him in mind. His story boiled down to this. He wanted the Institute to vote for abolition, but thought it unlikely. He hoped his alliance with Robert Jackson could change that, but the justice had died before a key meeting. He'd proposed the code's guided discretion provisions in light of the many jurisdictions that he knew would continue to keep the death penalty. And he was really disappointed that the code's alternative procedures had been totally ignored. He implied that he was also afraid that an abolition controversy at the ALI would cast a shadow on the general sentencing reforms that were at the core of his work. Even more importantly, his own views toward abolition were hopelessly tangled. To summarize what was really a complicated matter, He'd actually opposed abolition and argued for caution when he thought elimination of the sanction flew in the face of extreme public disapproval. In 1940, he'd written that a legitimate rationale for execution and harsh punishment was the desire for revenge, and I quote, "Too lenient sentence treatment of offenders may therefore lead to lynching, self-help, or indifference about prosecution." And as late as 1959, he said that doing away with capital punishment might invite the greater evil of private violence. If this language seems inconsistent with his abolitionist stance, it's perhaps well to remember that he was a great believer that the public had to become interested in the criminal process, and that stimulating that interest required that its voice be heard. An aside, many of you are familiar with Justice Stewart's language in Furman about how when people begin to believe that organized society is unwilling or unable to impose upon criminal offenders the punishment they deserve, then there are sown the seeds of anarchy, self-help, vigilante justice, and lynch law. This passage was, of course, requoted in the plurality opinion of Stewart, Powell, and Stevens in Gregg. Stewart's language about retribution is well known, but it's not usually pointed out that he was channeling Herb Wexler when he wrote it. But by the late 1950s, Wexler had come to the firm conclusion that the impact of the death penalty on criminal justice was and would be extremely negative. So we're at the point where the number of ironies becomes overwhelming. A brilliant but ambivalent scholar seeks to overthrow the death penalty. But when that proves impossible, he provides a means of applying it. However, nobody likes this formulation, except the lawyers at the Legal Defense Fund, who think they can use it as an effective tactic to challenge the then totally standardless system. Eventually, the United States government, in an amicus brief, takes the position before the Supreme Court that the code alternative, the guided discretion language, is just precatory. It's really only general education for juries rather than required principles. And in 1971, 7 justices of the Supreme Court more or less agree, and in McGautha, that even if the code really intended to constrain discretion, it really didn't do so, and it actually couldn't do so. The task is beyond human capacity. But of course, then in a blink of constitutional time, the court in Furman reaches the conclusion that the standardless system it accepted a year earlier is now unconstitutional under the fig leaf of a different clause of the Constitution. And as you all know, the hostile reaction to Furman is swift and clear. State legislatures embraced the previously labeled impossible code formulation, or at least part of it. The USA changes its position. And in Gregg, the court agrees over the objections of Brennan and Marshall and the LDF lawyers, who now, of course, find the code they once embraced as a tactic now fails to eliminate arbitrariness. Gregg disillusions the remaining 10 or 15 court watchers who believe that the High Court keeps clear of public opinion and politics. The scholar is defeated and ignored, but then his formulation emerges triumphant in bolstering a penalty he wanted to eliminate. Not quite what he intended. The justices embrace what they had just derided, a switch that comes about because they had totally misread public opinion. And naturally, they blame the anti-capital punishment lawyers for misleading them. And as for the lawyers and their clients, they'd chosen a tactic to stop executions, and over 600 lives are saved, but 40 years later, they're still stuck with the Wexler-based formulation. Even though it's derided by left and right alike for not doing what it's supposed to do, and rejected by several justices, mostly as they leave the court or have left the court. The Gregg principle still stands to justify the death penalty. For some reason that only a psychoanalyst could unravel, this series of events reminds me of the old Abbott and Costello routine, who's on first. Forgive me if you're too young to know what that's all about, but I assure you that a quick trip to Google will promptly inform you. If you've been sentenced, as I have, to a lifetime of reading Supreme Court opinions, I think you immediately recognize Gregg as essential formalism. In short, no argument about how the scheme is likely to work in practice will keep the justices from the result they've committed themselves to. The kindest thing you can say about such a decision, or such decisions, is they may leave to another day a move from the formal commitments of the first decision to subsequently take account of the lacks and realities of enforcement. Alas, such was not the future world according to Gregg. I don't have time to go into how subsequent case law destroyed even the weak promises of fairness slipped into the Gregg opinion, but it's probably enough to refer you to Zant v. Stevens and Pulley v. Harris to make the point. Zant invented the notion that aggravating circumstances play no role in guiding the discretion of the jury. They merely permit it to make an individualized determination of the life-death choice without any specific guidance. And Pulley rejected as a constitutional norm the comparative proportionality review that was praised in Gregg. I hope I'm not alone in finding the use of make-weights when rules are forged to govern life and death worthy of reproach. And perhaps a final irony, in 2009, the ALI, following one of Carroll's and Jordan's recommendations, decided to withdraw totally from the Wexler-guided discretion approach. Though, despite recommendations from the smartest people in the room, the Institute, and one might add the ABA, still can't bring itself to recommend ending the death penalty. The more you look at the last 40 years, the more you see a Furman-like world masked by the plausibility assumptions of the Gregg opinion. I recommend to everybody here who follows the Marshall Project to read Evan's post today elaborating on that subject. In 1962, flying back to New York from Lynchburg, Virginia, in an unpressurized DC-3 that made me sick, I was with my mentor, a man named James M. Nabrit III, a fabulous lawyer, and he was expressing frustration at a federal judge who, 8 years after Brown, merely ordered our named plaintiffs into the white schools and left the segregated system otherwise untouched. Jim exploded, and this was a guy who did not show emotion. I wish sometimes, he complained, that these judges would stop trying to follow their community politics and just enforce the law. I'm sure Jim could find just as many examples of judges he wanted to behave like statesmen rather than followers of precedent. But he certainly had a point when it came to local enforcement of Brown. Well, I felt the same way about Furman. It had no basis in precedent, but once the fateful step had been taken, the court could either stay with its anti-arbitrariness principle or bow to public opinion. Despite being trained at Yale by a bunch of realists and neo-realists, this time I wanted law, real law. Finally, I believe a life working in the world according to Gregg makes us a little nuts. You've probably heard of Obama derangement syndrome. I call this capital punishment derangement system, CPDS. Sometimes CPDS is obvious. Being accountable for the possible end of someone's life can be traumatic, even if you try to insulate yourself from feelings by calling attention to your professional role documenting a particularly absurd Gregg world screw-up that led to the death of a client, the late veteran defender Mike Mello wrote, quote, "The grief took me by the throat and wouldn't let me go." In our society, we've been taught that trauma leads to amnesia, but the novelist Edward St. Aubin, who had a youth of sexual abuse and heroin addiction, observed it also leads to splitting and fragmentation. I would add compartmentalizing. Splitting means separating ideas from feelings. Fragmenting means that the import of what's in front of you loses vital context. Compartmentalizing means keeping what you know or do in one role from what you know or do in another. We don't usually talk about this stuff, much less acknowledge the cost of splitting, fragmentation, and compartmentalizing. My submission is that CPDS affects those who have been seriously involved, regardless of pro or con, prosecutor or defense counsel, death row inmate, or victims, families, and friends. Judges and scholars do not have immunity. It's also there for litigators whose role requires dramatizing the agony of victims and the worth of the violent. It's there in the callousness and the sentimentality of much capital punishment talk and the absurd denials of racism. I shared these thoughts with my wife, and she said, "You got to give some examples." "No," I said, Gregg World CPDS is not the kind of craziness that gets you into the American Psychiatric Association's Diagnostic and Statistical Manual. The symptoms belong more in the category of what Freud called the psychopathology of everyday life. There isn't really a pill that promises relief. Most sufferers don't admit they have a problem. But she insisted, and when she insists, you know what I do. So here are 4 examples. I could give many, many more. First, when a great judge decides a case the wrong way, well, in the words of the departed justice, get over it. But when a great judge, and Judge Kaczynski is surely one, talks death penalty nonsense, well, probably CPDS is at work. He wrote some time ago in the New Yorker that death cases were, and I quote, meticulously litigated. Perhaps he was only talking about the Ninth Circuit, but then why the blindness to the rest of the universe? Good news is that the judge seems to be in recovery. If you want to read the best critique of the criminal justice system in a season of critiques, check out his preface to the 2015 Georgetown Law Journal, the annual review of criminal procedure. It's magnificent. Another example, in Massachusetts, where I come from, mind you, a state which has not had an execution in 69 years, it's almost as old as me, some local abolitionists have threatened to oppose efforts to eliminate or mitigate 1,000 life without parole sentences on the ground that it may lead to bringing back capital punishment. Now that's delusional, and it must be CPDS at work. Third, in the run-up to the recent California abolition referendum, numerous death row inmates actually publicly opposed the potential change to life sentences, as it might rob them of the attention they'd receive from being under a death sentence and the needed assistance of counsel to earn greater changes in their sentences. And one more, at least one state is currently embarking on a program to bring greater mental health services to death row inmates so that by curing them of their affliction, they might be more susceptible to be executed. So I haven't scratched the surface of examples, but my point is that the number of inconsistencies, missteps, vested interests, blocked feelings, cognitive distances, and denials may not amount to a constitutional argument, but nevertheless, they should give us pause, great pause. I'm closing out my 54th year in the death case business, and so given what I've just said, I probably should have been committed long ago. But so far I've managed to escape the guys in the white coats. If you do this work and you're worried about it, and you want to avoid CPDS, here's my prescription based on a lyric from a Broadway musical. Be kind to your colleagues, adversaries, and dancing partners, no matter who they may be, even though they don't deserve it. Remember they're grown-ups, a difficult stage of life. Thank you.
Three quick personal notes, if you'll allow me. One, if you're a junkie of this history, as I am, you may know that on March 3rd, 1968, there was a national conference on the death penalty hosted by LDF in New York City. And one of the striking features of the movement in the 60s and early 70s was the consolidation of LDF's authority. And that conference played a really important role in shaping the litigation that followed, and I can't help but think and hope that this conference will produce a similar result, albeit a more lasting one. Second, just wanted to say how thrilling it is. It's great to be here with George and particularly Michael. My work on my book, which took a really, really long time, its greatest gift to me was my friendship with Michael, who's one of the most extraordinary people I've ever met in my life. He's a loving guy. I never would have written the book without his assistance. And mostly what I thought is how thrilling it would have been to have been able to have been a lawyer with him. And I'm grateful to get to work with him if it's only for a day. I think you see in his comments why I love him so much. And can't help but think I'm trying to go with the right baseball player to honor you. It's like getting to play with Sandy Koufax for a day. Does that work? It's a good enough one? Robbie.
Jackie Robinson.
Oh, Jackie Robinson. Jeez. Robbie. Jackie Robinson works too. And third, I wanted to say, as a teacher, that I now know that professors also sit in the back of rooms too, just like students. Look, I thought for me, Jordan's framing comment is the right one, and to me, the only one that's interesting. The history, I certainly have a spectator's interest in it, but my work on my book, and I sense so much of the work that people do here, we're really only interested in the history as it's relevant to today. And that was always my agenda, and it continues to be really what interests me. And so I thought I'd just say a couple of things about the history that seem salient to me in framing, thinking about how we frame the discussion today. One, you all know this probably. Gregg is a historical accident. If Gregg had been decided by the justices with their collective wisdom at the end of their careers, it would have been a 6-3 decision striking the death penalty down as unconstitutional, either upholding Furman or maybe even going further. And it's a product of chronology of which justices were on the court at which time, some interpersonal, internal political dynamics, but it's not a decision, let's say, in comparison to Brown or some other civil rights landmark decisions which were previewed for years and where there were internal efforts within the court to build consensus. It has none of the hallmarks of those decisions, and as I'll tell you in a second, the bedrock principles of Gregg were essentially decided over a lunch at a restaurant called the Monocle, just as the deal that formed the foundation of Furman was effectively decided in a 2-hour conversation between Potter Stewart and Byron White. And unfortunately, the way we do law in the United States doesn't permit that kind of honest dialogue, where the Supreme Court can acknowledge that this isn't a decision that's analogous to Brown. We have to take the letter of the law at its face, but as I'll say in a second, and Mike alluded to, I don't really think even by the principles that the text that it actually articulated, that we've even come close to satisfying the principle that was laid out in Gregg. To understand Gregg, you need to understand one thing about Furman. You're hopeful to understand a lot, but one will do. The tectonics in 1972, Brannon, Douglas, Marshall, and Stewart were prepared to strike the death penalty down as unconstitutional. I don't think it's widely known, but Stewart had said to his clerks that he was prepared to write a colorful phrase, a short snapper, because he believed that the death penalty treated people as a means to an end and was therefore unconstitutional. Questioned why he voted the other way in MacArthur the year before. I speculate Harlan's death in the intervening year may have liberated him to some extent. Both of his clerks from that term put some weight in that, but we're not really sure. He said that he regarded the Eighth Amendment question as separate. Byron White plays the critical role in Furman. At the initial conference, White says he's going to vote to strike down the death penalty as unconstitutional. He almost immediately withdraws the vote, and then for the next 9 months, the court's in limbo. And there is a conference on June 9th, 1972, when Harry Blackmun asks the conference whether his opinion should be framed as a dissent or a concurring opinion, and the justices debate what White's vote had been in October with White in the room, and White doesn't say anything, and they leave. And Stewart returns to his chambers and says he's going to go talk to White. And I don't have a tape recording about what happened in that conversation, but I know what Stewart's position was on the death penalty before he went to White's chambers. I know what it was when he came out, and I know what his clerk said that he said. And it's clear that Stewart effectively struck a deal with White, and instead of writing an opinion opposing the death penalty on moral grounds, he was going to emphasize arbitrariness in application. All of you know that White had this very idiosyncratic, bizarre position, which was that the problem with the death penalty wasn't that it wasn't used frequently enough. And if you try to put yourself in Stewart's head, the question is why he thought that was a deal that was worth making. And remember, in 1968, in Witherspoon, Stewart had believed that that was going to tip the dominoes, and that was going to be the end of the death penalty. He was, of course, wrong, and he was spectacularly wrong in 1972, and I always wonder how it could be that a white male who spent his days with other white males and his weekend playing golf at Chevy Chase Country Club in the most cloistered and working environment in humankind could fail to have had his finger on the pulse of American society. But he did not, and he was wrong. And of course, Jordan and Carol have an amazing article which is about the disparity between text and subtext in this constitutional history, and it's similar to what I said before. If you could have an honest dialogue, if you could sit down with the Supreme Court justices, you'd say, hey, come on, you're not really committed to the death penalty. Gregg was a political compromise. That's not allowed. And in their piece, they talk about the difference, how everybody understood these decisions to be about race. It's obvious. It's in Powell's notes. It's in Blackmun's notes, and it's in all of the clerks say that. And yet, very little of the text of these decisions have anything to do with race. But because we're lawyers, we live with text. We don't get to deal with actual, real psychosocial dynamics. Anyway, Stewart's wrong. You all know what happens with the backlash, and the dynamics shift. So when the court conferences, and I guess the conference would be 40 years ago from 2 days from today, Berger, Rehnquist, White, and Powell are prepared to uphold both the guided discretion statutes and the mandatory statutes, and the case comes down to Stewart, Stevens, and Powell. And a couple of things struck me in all of my many conversations with the clerks from the period about what motivated them to strike the deal of their own, which was to reject the mandatory statutes and accept the guided discretion statutes. One was, and if any of you have read The Brethren, that theme of the justice's antipathy for Berger is entirely resonant with every conversation I ever had. The clerks, and remember, I'm having these conversations 36 years after the fact, and every one of them, at some point in the conversation, often it was the first thing they would say to me, told me what a dope they thought Berger was, and that their boss thought Berger was. So it's very clear that Powell in particular saw a need to establish a more moderate center. Stewart is greatly constrained by the text of what he wrote in 1972. He can't very well come around and say, I didn't really mean what I said then. Actually, I really oppose the death penalty because I think it treats people as a means to an end. And Stevens, we could probably spend a whole conference on Stevens's cognitive dissonance on the death penalty, but he's not there yet. And so they decide at this restaurant where Lewis Powell had a hamburger ordered medium. You could ask me why I know that. And they decided that they were going to split the baby, that they were going to uphold the guided discretion statutes, and they were going to reject the mandatory statutes. And here's what's striking about that, which I can only say will only have meaning in a room like this. So that leap, right, in that transformative moment, what those guided discretion statutes require makes all the difference. So I understand many people have a moralistic position against the death penalty and wouldn't kill under any circumstances. But if the Supreme Court had required that those guided discretion statutes say limited the number of aggravating factors, or required that the aggravating factors be written in objective terms as opposed to vague terms, the death penalty in the United States looks completely different than it does today. And maybe we'd have a spirited philosophical debate about whether the death penalty should ever be used, even in the case of terrorism or mass murder. But as I always say to my students, if it were reserved for the Hitlers of the world, I don't think I'd be losing sleep over it, and I'm sure there would be more significant causes to which so many brilliant people would have dedicated their life. But they didn't think about it, and it's astonishing. There's one conversation with Powell's clerk from the term Whitman, a really smart woman professor. They're all incredibly smart. And just how little and really no thought was put into whether or not these statutes would work. So one striking bit of this history, right? Where do you put the Texas statute? Is the Texas statute a guided discretion statute or a mandatory statute? We all know it's a mandatory statute. No thought about what this whatsoever. It actually causes Peggy Davis from LDF to lose sleep after the fact about whether the Legal Defense Fund should have required that Jurek get counsel for himself, get independent counsel for himself, because she thought that his case needed to be treated differently. But there's no thought about it, no effort to look to social science evidence. If you read the thing I wrote, maybe you could say in return, well, what was the quality of the social science evidence at the time? Maybe not great, but in their article, Sober Second Thoughts is what, 1999? Is it that one? 1995, it's 20 years, that article is 20 years old? That article is 20 years old. Wow, so we could do it. And when Jordan and Carroll wrote that article, which is sort of a qualitative way at looking at what the guided discretion statutes would do. What has the Supreme Court required with respect to aggravating factors? How seriously has it taken the requirement of narrowing a channel? And they said, look, if you look at the decisions and you look at what the law actually says, we can make a pretty good guess that they're not really doing what the court said they were supposed to do in Gregg. And now, after 40 years of data, right, we know that they don't do anything. And actually, I would make the argument, I made the argument, that in many ways, the arbitrariness of the system is substantially worse than it was before. Geographic arbitrariness is worse, right? It's almost exclusively a Southern phenomenon now. It was largely a Southern phenomenon before. If you look at the scope of our aggravating factors, which have just crept up in number over the years, right? You know, the data in California, 90% of cases satisfy one aggravating factor and are therefore death eligible. So this universe looks completely different if the court had gotten seriously into the business of what these statutes are supposed to look like, as opposed to saying, well, so long as you eliminate somebody, that's okay. But they've never done it. And the reason they've never done it stems back to this original decision, this original conference, where you just have this very, very gut reaction that we're going to split the baby without getting into the dynamics of it. Michael makes such an important point in pointing to Herbert Wexler, because Wexler and the model penal codes present presence was such a legitimizing force in this. It was a natural place for them to turn. And of course, in part of that conversation, they weren't going to say that Wexler himself had viewed it as a compromise and that he didn't actually have any data to support the position he said anyway. So I'm eager. I don't look forward to these things so much, but I've been looking forward to this for months. Really, really eager to hear the conversation ahead and happy to be here with you.
Good morning, everyone. I'm going to close our discussion by shifting a little bit. Michael and Evan have done a terrific job talking about the political and legal forces that were at play that produced, first, the rejection of the death penalty in Furman, and then later its embrace of Gregg and the guided discretion statutes. But I want to, before I begin, second Jordan's endorsement of both Evan and Michael's wonderful books. You don't have to be somebody who likes inside baseball to appreciate page after page the extraordinary nature of both of these books, so I commend them to you if you haven't already read them, if they're not on your shelf at home. What I want to speak about really briefly is not the theory of Gregg, but to talk about what forces existed on the ground in the mid-70s that were going to determine whether or not the promises of Gregg were fulfilled. And my chief, I think the reason why I'm doing this is because you can look at my hair. I used to have a lot of hair. It's no longer there. You can look at the color. I've been around long enough to know a little bit about this. And I want to ask the question as to whether these new statutes would begin to deliver capital sentences that were in fact less arbitrary, fairer than under the Furman administration, or whether we would see a lessening of racial discrimination that clearly was playing a large menacing role in the administration of the death penalty, and whether a decade after Gregg we'd be able to look back and say, we look at that new cohort of death row inmates, and yes, they do look like the worst of the worst, state after state. But I think, as all of us know, the history now shows that the states were furious at the court after the Gregg decision. They very swiftly, sometimes in special sessions, reconvened and passed the new statutes and got right back into the business without addressing other elements of a fair system that were absolutely crucial to these statutes operating fairly. So what happened in 1976 with the court's approval of the Gregg statutes is that they approved a structure that offered a hope of a less arbitrary system. Was bifurcation a good idea? It sure was, compared to Furman. There now would be a second phase of the trial, where for the first time you could put on evidence, not relevant to guilt, that might influence a jury to not impose the death penalty. This is a very significant improvement in the trial process. And there, in some of the statutes, there were some factors and circumstances that the judges would tell the jurors about to guide these debates. Also a good idea. Not so much in Texas, as Evan just alluded to, but surely in Florida and in Georgia. And on the appellate level, for the first time, there was this promise of enhanced review. Now those appellate courts would have to not simply look at the records and determine whether there was harmful error, but also, particularly in Georgia, had to, even if the trial was as fair as it could be, would have to make a further judgment as to whether this case was an outlier, whether it was proportional and should be allowed. So these were very big changes from Furman. I wish Wilbert Rideau had been able to come. Wilbert spent 10 years on death row in Louisiana. He was tried 3 times under the pre-Gregg system, unitary system. He had 3 juries, all white, all male. He had lawyers at each phase who had no money. There was no investigation. His first jury took 50 minutes to convict him and return its verdict of not only conviction, but of no mercy, death. His second jury took 10 minutes to convict him and offered their verdict of no mercy, and the third jury took 5 minutes to do so. So Wilbur would say the Gregg statutes were an improvement. They also imposed very new responsibilities upon the trial actors. If you were a defense lawyer, if you were appointed now under the Gregg statute to do a capital case, you had a lot more responsibility than you had under the Furman statutes. The statutes casted broadly, not narrowly, the type of factors and information that jurors could consider in deciding whether your client would be sentenced to life or death. And you had the responsibility to look for that information and present that information. And if you were appointed to do an appeal, your job was not simply to present any issue that might lead to reversal, but also to engage the court to say that even though the trial was fair, there are other arguments to show that you should nevertheless strike down the death penalty. Now, when other states later on confronted this question, we're going to reboot our capital system, they also saw that they needed to simply not rewrite their statute, but they had to upgrade and substantially upgrade both the prosecution function and the defense function. In 1995 in New York, when Governor Pataki beat Mario Cuomo, in no small part on his position that he would bring back the death penalty in New York, while George Pataki was no Rockefeller Republican, he and his staff recognized from the get-go that the prosecution in New York, as well as the defense, would need a lot more resources that the current indigent defense system simply couldn't support and faithfully carry out this new death penalty statute. And so it provided substantial additional funds for prosecutors so they could hire new lawyers and have special capital units, both at the trial level and for the appeal. New York had long talked about, if we ever brought back the death penalty, that they would recruit the best lawyers and would pay market rates. But then as Governor Pataki was costing this out, we're not going to do that. But to his credit, they put right in the belly of the statute, not off somewhere else in the statutes. They put right in the belly of that statute a capital defender office and funded it, at least for purposes of today, adequately. That statute passed in April. This death penalty came online on September 1st, and when that statute came online, there was a fully functioning capital defender office ready, willing, and able to take on those cases. And in the 8-year death penalty experiment in New York, it was vastly different than what we saw in the wake of Gregg. That cases, most of the capital cases, were settled after extensive discussions between the defense and the prosecution, informed by thousands of pages of mitigation, which oftentimes persuaded the prosecutors this was not a case that, while it looked at first, it was a case that death might be required, it no longer was. The system worked the way that the statute was designed for it to work. And the United States government, when it got back in the business, there's always been a process in the federal system to provide significantly more resources in these cases than any other state has done, and there's a process to improve that system. I must say that the problem in the federal system is the damn judges. In some parts of the country, they continue to appoint lawyers who are not qualified. They cut vouchers 50, 60, 70%. And in the state that we're here today, in the Fifth Circuit, there's no capital habeas unit or no capital trial unit in any of these states. That is leading to horrific problems. But mainly in the federal system, it's a much better system because there's been this process of re-examining and funding it properly. So what happened after Gregg in most of the states that very quickly rebooted their systems? Well, the systems, as we know, were not self-executing, and the states did absolutely nothing They took no step to see that the defense would be able to live up to its very new and very tough responsibilities. There was no new money passed in any state that I know of to ensure that the representation of capital defendants would be adequate. There was no capital defender office or appellate capital unit created in any state in the early years after Gregg. At most, I know of in Georgia and Florida, there were 1 half-day training sessions for the willing. But as we know in reading our cases, most of the lawyers who were appointed to these cases came from the Groucho Marx school of preparing for capital representation. 80% of life is simply showing up, and that's about all they did. But on the prosecution side, while there was not initially new money, there was a great advantage because the prosecutors had, in Florida, state's attorney's offices. They had district attorney's offices, and very quickly, lawyers in those offices developed great expertise in how to try these cases and how to do the appeals. Glenn Martin and Jim Hellickson in Clearwater have probably tried 30 capital cases, and they were the go-to standard, and they won most of those early cases. Joe Briley, who our great friend Steve Bright tussled with a couple of times, 33 capital cases he tried. And of course, Ed Carnes, now the chief judge of the 11th Circuit Court of Appeals. In the 70s and 80s, he was the head of the Capital Appeals Unit in the Alabama AG's office. He was involved in all the direct appeals. He was involved in many of the state post-conviction, the habeas cases. He was Mr. Death Penalty in Alabama. The courts, state and federal, would often defer to Ed because he was seen as such an expert. So, what reason would we have, looking back at 1978, 1980, 1982, that somehow these statutes were operating fairly? There is no evidence of that, frankly. In fact, the evidence seems to show that the pre-Furman system was still very firmly in place. Just as today, our indigent defense system in most parts of our country remains a mess, it's underfunded, it's not independent enough. In the 1970s and early 1980s, it was in a shambles in many places. In most of the death states, where we saw death rows rapidly becoming larger, there was no statewide public defense system at all. These systems were all county funded. There were no trial standards. The judges could appoint whomever they pleased, and oftentimes did. The fees that were available to counsel were ridiculously low. $500, maybe $1,000. Alabama, for years, for decades, the most you would get in representing a capital defendant there was $1,000 for out-of-court work and $1,000 for in-court work. There were not funds for experts. In fact, not just in this part of the country, all over the country. There was a study of the first 20 cases in Philadelphia. In those 20 cases, in only 8 were any fees awarded at all for investigators or mitigation specialists, and the average award was a whopping $605. And in many cases that I saw, there were no investigators appointed at all, and social workers or mitigation experts did not come online until the 90s. So, how did the system work? Very, very poorly. Let's look at the trial level. Charlie Young was represented in Georgia by a lawyer who'd never read the Gregg statute before trying the case. In a thundering closing argument at the end of the guilt phase, he urged the jury to convict his client, but to extend him mercy. He was interrupted by the judge saying, there's a second phase of the case. Charlie Young was death sentenced. No state court intervened. He got relief only in federal court. Jack House was represented by 2 lawyers also who had not read the statute. They did not know there was a second phase of the case. And this was not out in the woods someplace. This was in Atlanta, Georgia. In addition to not being prepared at all for the sentencing phase, the lead lawyer went out and was parking his car when the detective who took the confession, which House said was false, was testifying. And the lawyer came back in the courtroom and cross-examined that police officer without having heard his direct exam. This passed constitutional muster in the state courts of Georgia. House would only get relief in federal court. Donnie Thomas was a young 18-year-old terribly mentally ill. The jury never heard how mentally ill he was. And Steve Bright and I took this case. It was the first case we took, and we found out why. He represented 600 other clients in the year that he had this case. His office was 3 miles from the crime scene. He never went there. And there was no evidence presented at the penalty phase. Donnie Thomas did not get relief in the state court. He had to go to federal court to get that death sentence overturned. And Billy Burke was represented by a lawyer who he objected to. And in a post-conviction hearing, when the lawyer was asked to name criminal cases that he knew about, he could only cite 2, Miranda versus Arizona and Dred Scott. Now, these cases are extremes, and please forgive me if for those of you from Georgia who think that I'm picking on you, if Eden Harrington were up here, if Rob Owen were here, they could tell you of equally egregious cases in Texas. And if Marty McLean were from Florida, the same thing about Florida. But what's the takeaway from this is that while those cases are extreme, there were scores of these cases, not a few others, but scores of these cases where there was no evidence presented at all at the punishment phase. The juries were as equally ignorant of mitigating circumstances under the Gregg statutes as they had been for years under the Furman statutes. I think that I was in Atlanta for 5 years. I saw most of the first 200 cases argued, capital habeas that were heard in that court, and I know that at least 100 of those cases involved ineffective assistance claims where no mitigating evidence was introduced. Now, were things working any better on the appeals level? Well, consider Banda versus State, a Texas case where the lawyer raised only one issue and the argument was a mere 150 words long. Or how about the Heath case in Alabama, a one-page argument raising a single issue? Or what about the Morgan case in Georgia? The direct appeal brief was only 5 pages of argument. It was filed late and only after threat of sanction from the court. Counsel did not appear at oral argument. He just submitted the case. And when the court requested the filing of a supplemental brief, the lawyer never filed that brief. And what about the Waldrop case from Alabama? The clerk of the court wrote to Waldrop's counsel asking if the court would provide citations and case authority because his brief did not include one cited case in the entire brief. Instead of redoing the brief, the counsel later submitted just a list of cases. That was what was passing for advocacy in the wake of Gregg in these cases. And what's interesting is that while the Supreme Court had assumed and had heard the state advocates say, we will do our job under these statutes, that there will be this special super review on direct appeal, in none of those cases did any of those state Supreme Courts discharge counsel and appoint new counsel who could adequately and thoroughly brief the case up. And in each of those appeals, not surprisingly, those appeals were denied. Just like the list of cases we talked about a minute ago on the trial side, these are extreme examples of dysfunction on appeal, but they are not alone. There were scores of these cases where you'd see just hapless briefs written, 20-page briefs that wouldn't convince 3 abolitionists in this room to grant relief. In Arkansas, the long-time practice there in capital cases on direct appeal was do not show up for oral argument. Just represent your client on the briefs. And so really by not addressing, by not providing for an adequate indigent defense system, nothing really changed in the wake of Gregg. Is that these trials were operating just as they had before under Furman. Most of the juries had no information whatsoever. When it had to go back in their room and make one of the most important decisions those human beings would ever make, certainly one of the most consequential ones, whether to impose a life sentence or to impose a death sentence. And on we went. Thank you.
We have about 20 minutes of time for questions from people for any of the panelists.
this was a fantastic panel, and I'm very curious to ask you about, to ask all of you actually a little bit about projecting into the future. One of the things that Evan said, which is striking, which is that if Gregg were decided today by those same justices, if we could revive them, it would come out differently because 3 of them are on record, 2 while they were still on the bench, Blackmun and Stevens, and 1 post-retirement, Powell, as repudiating the constitutionality of the death penalty. And we now have Breyer and Ginsburg on record. These are all justices who have upheld hundreds, if not thousands, of death sentences in their time on the bench. And so there's this incredible change. You know, Michael, you talked about the psychology of people who work in this area. I'd love to hear all 3 of your thoughts about this rather extraordinary thing that we've seen in the post-Gregg era. I can think of no other area of constitutional law in which so many justices who initially promoted it, promulgated it, tried to make it work, have repudiated it so thoroughly. What's going on, and what's going to happen?
I'll just say this is the only thing Michael and I have ever disagreed about, so you'll see it. It'll be very civil.
Well, I'll start. I view this as, to a certain extent, psychological, but I think this is purely political, and you have to, in a way, shuttle off your lawyer persona, your precedent, your reading the cases persona to make a prediction. And I think you look at the politics that we've all been subjected to in the last 3 or 4 months and what we're likely to be subjected to for the rest of the year and for God knows how many months thereafter. And I think that's where one makes a prediction about the future of the death penalty. Eventually, will it go 99%? Yeah, but in Keynes's famous phrase, "In the long run, we're all dead." I think it's a purely political matter, and I think in the absence of truly committed appointments to the court, in number, you'll find even so-called liberal justices hesitating before they strike down the death penalty. I don't think I'll name names, but it's no accident that only 2 justices, that Breyer was joined only by Ruth Ginsburg. If 2 more justices had joined, you'd have a case before the Supreme Court, and it would have lost, in my judgment. And of the 2 who didn't sign, well, we'll see. I think there's a residue of viewing the death penalty in light of not the systemic, bureaucratized process that it is, that most people in this room perceive it as, but as a response to the heinousness of so many crimes that our culture seems to produce. And I think that's a massive stumbling block to a court that is increasingly politically sensitive. So that's where I am. Evan is in a different place.
Well, I'm glad Carol asked the question. I can't imagine that this conference would be doing what you meant to do if we didn't really spend some time talking about this, right? There's clearly a moment. It's interesting because clearly here the history is intersecting in a very conscious way. So if we take Breyer's dissent in Glossop as the starting point for this conversation, Adam Liptak wrote an article in the New York Times, which probably many of you read. Henderson, you're quoted in the article. I'll give you interesting insight. I had pitched that story to the New York Times Magazine, basically the exact article that he wrote, and he called me, and I said, oh, I had pitched it, and he goes, oh, you don't want to talk to me? And I was like, no, and I outlined the story. And I don't say this because I think he did something I never would have been able to do. So to me, the most important tidbit in the Times article is the reporting from Breyer's anonymous friends that Breyer was consciously evoking Arthur Goldberg's dissent in Rudolph versus Alabama. And we didn't go back far enough in the history, but that is the starting moment for this history. It's the starting moment for you. Goldberg and his law clerk, Alan Dershowitz, do some research. Doesn't go exactly the way Goldberg thinks it's going to do. He has a lot of respect for Earl Warren. He backs off, but he files this. He dissents from the denial of certiorari. He gets 2 other votes, and we've talked about this. In my recollection, they're having lunch on a picnic blanket in Central Park, but Michael tells me that wasn't the case, where they discussed this dissent.
Yeah, anyway.
The meals aren't that important.
Yeah, not important. But the fact that Breyer saw himself as recapturing the role that Goldberg had played in this history is very significant, because it says something about his state of mind, and it would, to my view, have been irresponsible for him to have published that dissent, knowing that it would be viewed as analogous to Goldberg's dissent, and also believing that the likely outcome was a 5-4 decision reaffirming Gregg and depriving litigators of their historical moment for the next 50 years or so, because surely the court's not going to take this up any sooner than that. So I put a lot of weight into Breyer's assessment. I am certainly sobered by Michael's judgment for many, many reasons. I do see, we've never discussed this, I've thought about it a lot. I do see from his position, having lived through this history, why he might be slightly more risk-averse interpreting this evidence. Not to say, he might very well be right, no one knows. Remember, LDF didn't set out to bring an Eighth Amendment challenge to the death penalty. LDF's strategy was to piecemeal the procedural arguments. And remember, Furman is a quirk of history. 1971, after MacArthur is decided, everybody thinks that's the end of it. If any of you teach the death penalty, I'm sure you've tried to explain to your students why a procedural decision is being litigated under the Eighth Amendment after the court had dispensed with the 14th Amendment due process challenge to these questions. So the court grants cert because Hugo Black wants to clean up the loose end. And of course, back to Jordan's initial point, anybody who tries to read the tea leaves here, boy, Hugo Black sure didn't see what was coming. So I would not prognosticate anything with any confidence, but I do think Breyer's, we can read a lot into Breyer's state of mind, both by the fact of the issuance of the dissent and the comments to Liptak that Breyer was conscious of what he was doing, which of course I think anybody would have presumed.
Surely the conditions today are much more favorable. When you go back and read these 2 wonderful books, you see that the consensus was entirely in favor of keeping the death penalty. There were over 40 states that had the death penalty. While there had been this moratorium, there is not the record now that we have today of state after state now rejecting the death penalty. It's hard now. Ginny Sloan tries to find people who support the death penalty to come on and talk about that, and it's getting harder and harder to do. So all those things are well, but I feel like the management labor lawyers this week learned a very tough lesson, that they thought that they were going to win that big labor case that was going to really hurt public labor unions. And the argument could not have gone better for them in January, and then a key member of the court passes away. And, you know, Ruth Bader Ginsburg is 82 years old, and so there's so many vagaries here. And I think one other thing never to forget is the hallmark of the death penalty: nobody wants to take responsibility for it. One of the reasons why we humiliate ourselves in the eyes of the world as a leading democracy is the way that we just show our disdain and our contempt for the humanity of people who are facing the death penalty or who are on death row. We violate all our principles in the way we've been enforcing the death penalty for years. So while the tea leaves are favorable, it's still a very tricky path to get there.
Well, I concur. I certainly concur with what George just said. A few odds and ends. Goldberg's opinion, the dissent in Rudolph, certainly agitated us at the Legal Defense Fund. In fact, we were involved in numerous death cases before, but had never taken a view that we could really mount a campaign. But the key element for me always in the Rudolph dissent was that remember, this is a dissent from the denial of cert in rape cases in the South, interracial rape cases. It never mentions race as a ground for the unconstitutionality of capital punishment. And the subsequent history, as has been stated several times even this morning, is that the court has never confronted that issue. So one little thing that would tell me that there was a reasonable opportunity in the short term for abolition would be if I saw some sign of a shift there. Secondly, the indeterminacy of this evokes for me, being of a certain age, how in the 1950s learned public intellectuals would say, well, Malenkov is next to Khrushchev, whereas last time Khrushchev was too over to the left. And so perhaps Malenkov is going to be the next man who will seize power and not Beria. I think this a greater predictor, if one wants to get into the game of predicting, is the general political sense of what's going on in this country. And regardless of who wins the election, although that may conceivably produce the only good predictors, there's an enormous foundational fear of something that is usually labeled terrorism, and that plays a role in the kind of blowback that a Supreme Court justice who is confronting whether to trim in this issue, cut back here, cut back there, or let the system go pretty much the way it is for a while, or take this big step of abolishing with all the consequences that may mean for a court that has already been through that in the post-Furman reaction.
I'm going to make two brief comments. One, the connection between Justice Breyer and Justice Goldberg's dissents was made even more riveting to me when I learned recently. I hadn't recognized that Justice Breyer had clerked for Justice Goldberg the term after the Rudolph versus Alabama dissent from denial. So he was exquisitely aware of what Justice Goldberg had done and the significance of what he had done, and calling attention to the possible unconstitutionality of the death penalty in a context that had never before had that issue raised. So it made me lean more towards Evan's view that that this might have been more of a self-conscious invitation rather than sort of a personal assessment of the state of things. And the second point I want to say is, just given the ambivalence about predictions about the future, we always have to go back to Yogi Berra, who said, making predictions is difficult, especially about the future.
We should note that Michael's Kremlinology jokes really used to kill. I'd just say two odds and ends things also. One, Breyer could be wrong, right? That's important to note. We have in this history itself many instances of Supreme Court justices massively miscalculating both public opinion and the internal dynamics on the court. So if nothing else, we have to be sober about that. But when I think about the decision that George and Henderson and Steve faced about where to proceed, I do think the costs and benefits are categorically different than they were in the early 1970s. It's very, very hard for me to imagine a massive backlash of public support for the death penalty if a decision went the wrong way. But say again, no
Sam Gross?
On that precise point, Evan, that's what I've thought for a while, and that's why I've been somewhat optimistic, although not as much as some people. But then there's Voldemort, or whatever his name is, who's running for president as a Republican, although he's not, and who's managed to stir up passions on the right in a way that nobody anticipated. I don't know what his position on the death penalty is. I know what his position on torture is. I know I do. But I think without torture, I think he thinks it's too quick. I think his position on the death penalty is that lethal injection isn't sufficiently painful, so maybe he's against it. What? I know. No, I'm joking. It's not been a central issue in the campaign, but it begins to make me wonder if there might not be a fear of backlash on the right of a sort that nobody anticipated just 6 or 10 months ago.
Hi, can you hear me? Yes. I have a big voice. I have a big voice too. My name's Roberta Harding. I teach at the University of Kentucky College of Law and represent capital defendants in Kentucky, where there's not a lot of money, and we have several prosecutors. Actually, that's an example of the geography. There's basically only 2 counties where the prosecutors will seek the death penalty. One of them is Fayette County. The prosecutor, Commonwealth Attorney Ray Larson, who hates me, and the police hate me, as my students tell me, because they don't do their job right, and I beat them in court. I'm actually writing an article, I have been for about last year, about revisiting the constitutionality of the death penalty for the crime of aggravated murder, revisiting Gregg. And I actually am optimistic, especially the longer it's taken me. There's been more states that have abolished it, so that helps my argument. With respect to the trend that the court talks about in Atkins and Roper. But one question is for Evan, when we were talking about Furman and then Gregg and Stewart and White, my students, I asked them this: why did the court in Gregg say, yes, guided discretion is constitutionally, comports with Furman, even though Stewart's language in Furman, he says the Constitution will not tolerate the imposition, the arbitrary and capricious imposition of the death penalty. But then in Gregg, he says, Furman only requires that you minimize or reduce the risk. I don't know the answer. I tell him I don't know. What he says in Furman would suggest, we have to abolish it because we can't come up with a scheme that will eliminate it.
Well, two interesting things on that. One, the phrase which most of us regard as the signature line from
Furman, that being the death penalty is, analogous to being struck by lightning, was written over the course of a weekend following that June 9th conference. That language had never appeared before. It's not in any of the memos that Stewart's clerks generated. And actually, if you go to my website and you click on gallery, you can see a photograph of the yellow legal pad that Stewart wrote it on with the crossouts. So, that principle was very hastily decided. Not surprisingly, his commitment to that principle isn't very sophisticated. And I think, again, to say why it's so important that Michael drew attention to Wexler, and so important, thanks to Carol and Jordan and many others, that the ALI has finally excised that provision of the Model Penal Code. They're lawyers first and foremost, and I don't think I don't think they're paying lip service. I think they have really kind of an unquestioning faith in the power of law. It's very profound for Powell. Powell clearly believed that the laws had a potentially ameliorative power, but they just didn't think it through. I mean, it's a very instinctual decision, and more problematic by how hastily Stewart arrived at it. I also just was going to use what you said to launch an interesting question, which I'm sure we'll discuss over the next few days, which is what the constitutional argument would look like to the Supreme Court today. And I think you see some of the fault lines on that have been drawn within the scholarly community. One is to say that Furman's mandate hasn't been satisfied along the lines of that, the mandate of reducing arbitrariness in all these different contexts, geographically, in terms of reserving the death penalty for the worst of the worst, disparate race effect, hasn't gotten any better. Another argument is Rob Smith, if any of you read an article, it's called Forgetting Furman, which he published, I guess within the past few months, makes the argument that really the argument should be more focused on the types of people who are being targeted for the death penalty, and that really collectively they don't have the culpability that's required. It's a very important, weighty decision. I do think when you reference the trend evidence, since we know the court isn't going to say the psychologically honest thing and say, look, we're all lawyers, we really have we don't have much commitment to the death penalty as a mode of punishment, and we really don't think, informed by experience, that the law has the capacity to apply this system with minimal rationality. They won't be able to just say that explicitly, and they do have legal textual hooks upon which they could hang their hat. So the trend argument would do it, even though probably if we were debating this in the death penalty class, in a law school class, it's not the intellectually soundest argument, but it's enough. They have a basis to do it.
Would everyone please join me in thanking this first panel?